Welcome again to everyone for this year's Crammer, especially for those of you that weren't able to join us earlier this week. The idea of the Crammer is that you have a year's worth of legal content, case law and highlights in bite-sized sessions, and that's what's been the order of the week so far. We'll be doing a wrap-up of our Monday, Tuesday, Wednesday, and Thursday sessions at the end of today's session. And yes, I'm very excited to have, I've been told that there are about 40 plus of you in the conference already, and I'm sure those numbers will grow. 48, I hear. That's great. That's more people than came to my wedding. In recognition that business has been extremely hard for many, please don't forget that we're showcasing videos of unique, challenging, or unusual stories on our website at the end of each day's session. In this way, we hope that the storytellers and audience can use the Crammer platform to learn from a variety of different experiences and hardship and ultimately support each other. These unusual stories will continue to be showcased after the Crammer and promoted through social media, so it's not too late to send one in to marketing@adams.africa. Today's session is titled Unusually Private. But before we do that, I'm going to introduce you to the speakers. Up front, we'll have Demi Pretorius and I. We recorded a discussion last week, and the topic of the discussion is on liability, which you can work out is online liability. The session, or the short video, will explore the legal implications of social media posts and direct messages, cybercrimes, defamation by emoticons, and contractual liability. Then we'll have Nicole Smallburger talking about copyright in relation to your virtual self. So that will include a discussion on avatars, and there's a really exciting video and contraption that Nicole uses up front, which will definitely be a fun element of today's session. And she'll also be discussing copyright in tattoos based on the recent case in the States, which discussed the copyright in your tattoos in relation to video games. Then we'll have Danielle Roberts talking us through POPIA and the implications for your business in 2020. Of course, POPIA is a very topical discussion at the moment. We'll have unusual stories from Sunay Nadine and Novo Brands. And at the end of today's session, we'll have a wrap up from each of the sessions from the MCs from earlier this week. So without further delay, we'll get the session started off with the video recorded with me and Demi Pretorius. Thank you.
Hi, Demi. How are you?
Hey, Nick. Good, thanks. Nice to be here.
Yeah, thank you. Welcome to my talk show. Yeah, we're talking about online liability today, and effectively how an individual might attract liability for their conduct online. Yeah, it makes me think of we often talk about the keyboard warriors, people who think they are invincible because they're sitting behind a keyboard and firing off all sorts of nasty things. And I think that those people think that they're protected because they are like in their pajamas in their lounge. That one of the things we're going to talk about today is the fact that actually there's real life consequences for your conduct online. And maybe Demi, can you talk us through fake news and the legal developments in South Africa this year?
Fake news, yeah, hot topic. The second pandemic, as some people call it, has actually now been criminalized. So after the announcement of the national lockdown, the government actually issued regulations in terms of which sending false information with the intention to deceive is actually now criminalized. And if convicted, you can be held liable for a fine or imprisonment or both. So it's very serious, and that actually comes from people sending these fake news, false information over WhatsApp.
So specifically, COVID-related misinformation.
COVID-related.
With the you intentionally deceiving someone.
Yes.
So it's not if your mom might have sent you that one of those WhatsApps and it was wrong. It was fake news, but she didn't have that intention.
Well, not necessarily direct intent.
Okay.
Even where you have you're not certain whether something is true or not. Or you foresee that something might not be true and someone will believe it, you can still be held accountable. So just be very careful when sending those false information.
Okay, and that so that's catering for the COVID-related misinformation, but then we also have the cybercrimes bill.
Yeah, that's very new right now, and essentially takes this issue about fake news regarding COVID a bit further. So the cybercrimes bill criminalizes many things conduct online, including malicious messages, data messages, be it via WhatsApp, over social media, Facebook, Twitter, you name it. And essentially, when you send a message with an intent to incite, to cause damage to property or to harm a person or to offend a group of people, you can now be held criminally liable if the president assents to that.
Okay, so we're almost there.
We're almost there.
We're almost there. Demi, there was an interesting case that the Supreme Court of Appeal gave in December last year, known as the WhatsApp case, and it was about a lottery winner that won. He won 20 million rand, and that's when people start coming to running after you, asking for some. And it was he had sent a message to the mother of one of his children, and said, if I won 20 million rand, I could give 1 million to each of my children and still have 13 million rand. And then she said she found out that he did win 20 million rand, and there was a judgment that had to decide whether he owed his one child or the mother of that child 1 million rand.
Yeah,
it's quite an interesting case.
Yeah, whether a contract came into being, essentially. Very interesting set of facts. Not really anything new on the legal front.
Okay.
Law in that regard is quite established, but I was so happy that that judgment was actually published, because I think it allowed the public to just think more about what they do online. I don't think many people realize that sending a message over WhatsApp could bind you contractually in a court of law. So just an interesting public debate surrounding contracting over social media. And of course, that is the case. In commercial context, if there is an offer and there's an acceptance, you get a legally binding and enforceable agreement.
Yeah. So the High Court in that one actually sympathized with the mom and said, yeah, no, she must get 1 million.
No, unfortunately not.
But the SCA, very
exactly,
firm on this.
Yes, you're correct. That is so.
Very, very firm on the fact that
that is so.
Yeah, but if you'd frame that, I guess one of the takeaways there from that case is that if he clearly said, like, if I won 20 million, I could. Where, like, if he tightened that language up a little bit, saying, like, I'm buying tickets, if I win, I undertake, could have been a very different outcome.
Like anything else in our law, when a court looks at any specific matter that it has to decide on, it looks at the specific facts of the matter. In that case, the court didn't find any intention by the lotto winner to be bound by a contract. He actually said it after he had won the lottery, and the court found that the way that he said it was just evident that he actually didn't want to pay the money. He's lucky there.
So we'll share a link to that judgment. Very interesting one. Also a link to Lotto. You can buy your tickets for the tomorrow's lottery. Yeah, I think that is a very interesting example because, we're often presented with, so more and more they're novel facts, and we're stepping into Instagram and TikTok and WhatsApp and Facebook, but effectively the courts dialed things back there and gone to first principles of contract. Is there offer?
Yeah.
Is there acceptance? Like, do you have a consensus between the parties?
The law is established. It's just being applied in a different context.
Okay. Well, there's a very interesting matter, not a published judgment, but made it into the news regarding one of our healthcare giants, big building in Sanson, and they dismissed 10 of their employees for their conduct on a WhatsApp group where they were undermining the employer, suggesting that they might overthrow their employer somehow. And based on the facts that we have, seems quite an interesting one, because obviously that's definitely taking quite a big step into your private domain on a WhatsApp group amongst colleagues. For sure.
Look, Nick, as you've pointed out, I can't say too much about the case. There's no reported judgment. I understand that the matter is still in the ECA, so I only know the facts as they were published in the media. What I can say is that this health giant wasn't the first employer to dismiss an employee due to what they've posted online. And there's a plethora of case law that deals with a situation where the labor law, the labor court and the labor appeals court has held that there's an entitlement by an employer to use what's posted online as part of this process, the disciplinary hearing process, to come to a finding with negative consequences. You can use that in support of a decision to dismiss an employee. And just again, another warning to all internet users that the lines are blurred. You can't distance yourself and say that, oh, I did this after hours, so my employer can't hold me accountable. In fact, many law firms, many entities, any type of business generally has a social media policy or a IT policy that would regulate that sort of
when you
communications.
Log in,
Exactly. Yes, you don't even really notice it. You open up your computer and you click OK, and immediately you consent to being monitored. And RICA even allows that. When someone consents to the information being intercepted or monitored, that act is legal. And so again, be careful about what you post
and
online.
What RICA is trying to govern is spying on people without their consent. So yeah, obviously getting hold of access to people's data that's not your employer, not subject to some agreement that you might have. Obviously that's where RICA is protecting the individual.
Except where you have a conversation with an individual and that individual still has a right to broadcast that information further. If you and I have a WhatsApp chat, maybe I send you an explicit photo, and you don't like that very much, you're fully entitled to go to your employer and to say, listen, this is what Demi's done. I feel harassed. And that employer can take action.
Yeah. That's really interesting, Demi. Thank you. Demi, can you give us just a few key takeouts from like what we've discussed today?
First and foremost, I would say know that your online conduct has real life consequences. No one is anonymous online. Twitter will find you and the courts will nail you. Secondly, and I suppose this is linked to the first point, is think before you click. Be mindful of what you're putting out online. There are repercussions, and they are broad. It can extend to being sued, being held criminally liable, or maybe you're a social media influencer. You can lose your social media following. You can lose endorsements. You can lose sponsorships. You can lose contracts. Think before you click. And then last but not least, disassociate yourself from any unlawful contact, particularly in those private WhatsApp groups and Facebook groups, where if someone says something that's unlawful, say that you don't agree, or leave that group so that you are not associated.
Yeah.
Leave that WhatsApp group.
What were we taught in our first year of articles about what you put in? Yeah.
Listen, I think the first lesson that I learned when I entered my legal career was that you do not put anything in a letter that you don't want a court to read aloud. And I think that principle has become so much more relevant to everybody who has internet access in this new digital age. Essentially, anything that you put out, as I said, has consequences. So I think just when you say something, make sure it's lawful. To test whether it's lawful as a starting point, you would look at whether it's true and whether you would say that before a crowd of people, particularly that has influence over your life or over your career, like your employer, your mom. If you don't want to say it in front of them, you probably shouldn't be saying it at all.
And they used to say, don't, like think of your tweets or your Facebook posts as like something that you put next to your face on a billboard.
The billboard test, yes,
test,
exactly.
But actually, it's not just, as we've discussed today, it's not just the open tweets and the open Facebook posts. It's also private messages that you send that might cause harm, conduct in WhatsApp groups.
Exactly.
Yeah.
Absolutely everything.
Awesome. Thank you, Demi. It's been really useful and really interesting.
Nice chatting to you, Nick.
Good to see you.
Start again.
Hi. The classic you're on mute situation. Sorry about that. I was just telling a quick anecdote that I was telling a story about realizing at our video that we were that we were recording in front of a green screen, and I was wearing a green bow tie, and we were very relieved to see that there wasn't a gaping hole in the middle of my neck. So that was, if it didn't make sense with that mute, that's of course it. So we had a few questions coming through, Demi. Thank you very much for your insights there. The one question from Millicent Zondi is, Facebook accounts get hacked quite frequently. Who's liable for the harmful messages that the hacker sends through to one's account? Is it the account owner, Facebook, or hacker? That's obviously something that we actually discussed. There was a recent case, not too dissimilar from those facts, more about contract law though. So maybe you could give us some perspectives on that, Demi.
Thanks, Nick. There are actually statutes that are being drafted all over the world to deal with that question, and they generally provide for the service provider to be protected and not the individual. you'll probably also find that Facebook's terms and conditions will free them from liability. To escape liability as an individual account holder, one would have to prove that the device from which the harmful message was sent was compromised, and therefore that the intention to be bound by the particular contract or to escape liability from that message, that intention was absent. You pointed out the ACA case, which I think is also relevant, which I do think is relevant. There, the ACA was required to determine whether a financial services provider acted in breach of a client's mandate by releasing funds to a third party upon receiving a fraudulent email instruction from a client's own Gmail account. And the court in that case found that the client could not be bound by the contract because he never authorized the instruction. And the person who did send the message was not authorized to do so. So we saw the ACA come up for private rights, which I think is a positive development.
Awesome, thanks, Demi. The other question relates to the use of emoticons and whether an emoji can amount to defamation. Do you have any views on that?
So emoticons are illustrations which are capable of being given meaning, and therefore my view is that the potential exists for an emoji to create liability, particularly in the form of defamation, but possibly also in the contractual sphere. For example, accepting a contract with a thumbs up emoji, or in the workplace, just think about the implications of a colleague or a superior sending a kiss emoji to you. As far as I know, the South African courts have not been confronted with that question, but specifically whether an emoticon could constitute defamation. But other legal jurisdictions, including the US and Australia, have in both those jurisdictions, the courts held that emojis are capable of conveying a defamatory message.
Awesome.
So yes.
Fantastic, thank you, Demi. Those really really awesome insights that you gave in the Q&A, and yeah, we might struggle to get to all the questions today. But we'll do our best to be able to answer them over email. So keep them coming, and you can. Demi will stay on the call for the rest of today's session. So while your question might not make it into the live video, it won't be the end of the day. You'll still get your question answered. So thank you, Demi. I would just like to introduce our next speaker, which is Nicole Smallburger. She's a senior associate in our Pretoria office in the trademarks team, and she'll be talking through copyright in relation to your virtual selves. And I've mentioned this earlier, but yeah, fascinating discussion, and keep the questions coming in the sidebar, because we'll be having a Q&A with Nicole afterwards. Thank you.
One of the big takeaways from 2020 has been that the world is becoming increasingly virtual. Business meetings to birthday parties and even IP crammers are being conducted in the virtual space. Avatars of ourselves, being animated representations or icons of ourselves, are popping into our social media feeds and expanding on the ways in which we can express ourselves and interact on these forums. But avatars are not all about frivolity and fun on Facebook. Filmmakers, animators, video game makers, and advertisers need to be aware of the legal implications of avatars and virtual reality, specifically the IP implications, and that necessary clearances must be in place before making the leap into the virtual world. Failure to consider these issues will likely mean that virtual world conduct will spill over into real-life legal disputes. The first potential issue to consider is personality property or identity rights. Let's say you create an avatar of a real individual, a celebrity perhaps, for use in advertising. You would certainly need that person's consent to do so. Each of us has the right to benefit commercially and exploit elements of our own identity. And certainly where celebrities are concerned, that right is a lucrative one. Best practice would be to reach out for consent. Failure to do so may land you in hot water with a legal dispute coming your way. But I mentioned that there may be instances where use of an avatar might not attract legal disputes. For example, an artist who creates an avatar for fair comment, for parody or artistic expression may be allowed to do so if his or her right to freedom of expression outweighs the individual's identity rights. But think about identity rights before going ahead with avatars. What about trademark rights? Let's say you create an avatar of a person who sports a well-known logo on his or her t-shirt. You may well receive demands from the trademark owner alleging trademark infringement, passing off, dilution. Again, a few interesting questions arise. In order to constitute trademark infringement, the use in issue must be trademark use. In other words, use aimed at denoting a brand origin, use that will create confusion or deception, or take unfair advantage of the brand in question. Whether or not that is the case will need to be assessed on a case-by-case basis. Another interesting question is, if a trademark is registered for certain actual goods, would protection extend to virtual, intangible goods? There are many virtual worlds in which one can purchase with real hard cash virtual goods for use in that world. I would argue that if you're purchasing virtual goods that are branded and you do so without consent, you would be infringing a trademark. Again, each case will have to be assessed on its own facts. Copyright issues are certainly likely to arise. Let's say you want to use music in your virtual world. You would need to obtain the appropriate licenses. Or what if you create an avatar of a singer who belts out a few hits, but you do so without license? You would almost certainly be infringing the copyright in the musical work. Those are arguably more obvious copyright issues, but there are others that are more obscure. Most of us were first introduced to avatars through the medium of video games. And it's through this particular medium that a very interesting, very 21st century has come up for consideration in the United States. An entity called Solid Oak Sketches, in a rather astute business move, acquired the copyrights in tattoos of various celebrities. Take-Two Interactive, a video game maker, to its great surprise, found itself on the receiving end of a copyright infringement claim from Solid Oak. But why? Take-Two had created avatars of well-known basketball players for use in its game, NBA 2K. And the players' tattoos appeared on their avatars. This, said Solid Oak, amounted to copyright infringement. Let's pause for a second to consider tattoos as a copyright work. If a tattoo is an original artistic work, in other words, it's not entirely commonplace, it's not cookie cutter, it's not the stock standard mom heart tattoo, and it's reduced to a material form, even if that material form is somebody's skin, then copyright will subsist. In the case of artistic works, it's the artist who owns the copyright in the work, unless, of course, the rights are transferred to someone else, as in the case of Solid Oak. That's perhaps a mind-boggling consideration for many of us, that somebody else could own rights in something that appears on our skin. but it is the case. So there was no reason why Solid Oak couldn't assert copyright in tattoos. Of course, because of the nature of tattoos, being on someone's skin, a common sense approach must be taken. There must surely be an implied license from the tattoo artist to the person being tattooed that this person will use the tattoo in his or her everyday life, including being photographed or otherwise depicted with the tattoo. After all, the tattoo becomes part of this person's identity. In NBA 2K, however, these were not real-life photographs or video footage of the basketball players. And the question was, did the tattoos need to appear in the game? So how did the court assess this? First of all, the court agreed with Take-Two's arguments that the use of tattoos in the game was insubstantial. It was de minimis. It was really background in nature, and it constituted fair use. After all, the disputed tattoos appeared on only a handful, 4 out of over 400 players that featured in the game. And the focus of the game was basketball, not tattoos. The court also found that creating realistic depictions of the players' likenesses amounted to fair use, particularly in view of the indistinct manner in which they appeared in the game. The players in issue also provided affidavits confirming that they had indeed licensed the use of their likenesses to the NBA, and the NBA had in turn given the game the green light. For its part, Solid Oak argued that it was possible to zoom in and view in detail a particular avatar, including his tattoos, but it failed to adduce sufficient evidence of this allegation. The copyright infringement claim was therefore dismissed. Tattoos on the avatars, fair use. So does this mean that video game makers and others have free rein to use avatars? Certainly not. All of the legal considerations that I've discussed, identity rights, copyright, trademarks, must be borne in mind and considered. Ensure that you have all of the relevant IP clearances in place. And virtual reality is an outside-of-the-box medium. So I would say you need to think outside of the box when it comes to clearance. The tattoo case proved that. Perhaps I can end with this. If any of you out there bear some impressive body art, consider taking assignment of the copyright in your tattoos. That way you know that you and your avatar have all the rights in what appears on your skin.
Thanks, Nicole. That was fascinating and really nice to meet your emoji. I've heard one of the anecdotes of virtual reality is that some people end up falling off things or bumping into things when they've got their goggles on. One of the questions relate to what other types of legal issues can be relevant to virtual reality aside from the copyright ones you discussed.
Look, it's a really interesting field, Nick. I think virtual reality is so dynamic and it's growing every day, changing and so many new issues coming up. It's extremely broad. I think one of the big ones is if you're creating a virtual reality world, then privacy and data protection issues are going to be very relevant. You're going to be collecting data about the users of your virtual world. But apart from that, there have been cases and disputes as broad and diverse as everything from divorce, where grounds are raised sort of along the lines of my spouse's avatar is getting a little too cozy with someone else's avatar in a virtual world. So virtual adultery, if you will, to theft. I've purchased a virtual item for use in a virtual world and someone else has taken it from me and sold it on, for example. So there have been cases, not in South Africa, but abroad, dealing with such a diverse range of issues.
Oh, awesome. Another question is relating to tattoos. If you and your tattoo artist design a tattoo together, who owns the copyright?
Well, the the artist, so the person who actually creates the artistic work, is the owner of copyright in this work. And if you and your tattoo artist do this in a collaboration, then you're actually joint owners of the copyright in that work. So both of you.
Fantastic. And then another question was, you know, whether you would own copyright in your own avatar. So you create it in a virtual reality world. Would you own that copyright?
Well, it's a great question. I think the answer, as with all good legal questions, is it depends. So the avatars we're used to, WhatsApp and Facebook, there you're really taking pre-created elements that Facebook has created, almost like a paper doll, and just putting them together. So there's not a great deal of you know, creative input from you there. But if you are using an app or a computer program, which is really no more than a tool, where all of the creative effort and design work is coming from you, then certainly you would likely own the copyright in that instance.
Fantastic. Thank you, Nicole. Really interesting discussion. And up next, we have Danielle Robertson, and her topic is business as per unusual in our unusual Crammer. And she's going to be discussing POPIA and the changing landscape for businesses in 2020, now that we have some hot news off the press relating to our Protection from Personal Information Act. Thank you, Nicole. And yes, look forward to your chat now, Danielle. And please keep the Q&As coming.
By now you would have heard of the Protection of Personal Information Act, which is more commonly known as the POPIA Act or POPIA. POPIA is South Africa's dedicated data protection legislation, and it aims to give effect to the constitutional right to privacy. It was assented to as far back as November 2013, but the key operational or substantive provisions of the Act only came into force this year on the 1st of July 2020. The substantive provisions include conditions for processing personal information, procedures for dealing with complaints, and provisions that regulate direct marketing by means of unsolicited electronic communications. Anyone who processes personal information in South Africa, be it a South African resident or a foreign entity, will have a grace period of 1 year from the 1st of July within which to comply with the provisions of the Act. From a South African perspective, POPIA is a rather unusual piece of legislation, and it no doubt came into force during rather unusual times. POPIA significantly affects how personal information is processed in South Africa, and there really is a lot to be said about the application of the Act. But for this talk, I'll only briefly highlight POPIA's application with respect to two unusual topics, namely the concept of working from home as well as direct marketing. Before I discuss these items, I'll highlight some key or must-know aspects about the Act. Firstly, what does the Act actually do? So POPIA essentially regulates the collection, storage, and dissemination of the personal information of both individuals as well as companies in South Africa. It requires the processing of personal information to be relevant and not excessive in relation to the purpose for which it is processed. In doing so, the Act seeks to protect individuals and companies from harm by safeguarding their personal information. In order to accomplish this, the Act sets out 8 conditions that must be adhered to by anyone who processes personal information in South Africa. In a nutshell, these conditions require responsibility, security, and consent in the processing of personal information. The Act also provides special protection for certain distinct categories of information and the information of children. So secondly, to whom does the Act apply? It applies to anyone processing personal information in South Africa. This includes companies, employers, as well as individuals. In other words, it applies to you, your boss, the company you work for, and any business that collects your personal information. POPIA also regulates every aspect involved in the processing of personal information, from its collection to its destruction. It's important to note, however, that POPIA doesn't apply to the processing of personal information for purely personal or household purposes, or for journalistic or artistic purposes. So in summary, the Act specifically applies to businesses and individuals processing information in South Africa in the course and scope of a commercial activity. Now, thirdly, Why should you or your business care about data privacy? Well, from a business perspective, if your business processes the personal information of your customers or your employees, and that information is leaked, you or your business could be held liable under the Act for fines of up to 10 million rand, and you personally could face imprisonment of up to 10 years. Now, under the Act, everyone processing personal information needs to take steps to secure the integrity and the confidentiality of that information. Measures also need to be taken to prevent the loss, damage, unauthorized destruction, or access to personal information. If personal information is, for example, accessed or obtained by an unauthorized person, the Act places an obligation on a party from whom the information was obtained to report it in writing to both the information regulator as well as to the party whose information was compromised. Traditionally, this obligation to inform the party whose data was compromised did not exist. Now, if a data compromise occurs, it doesn't only mean that your business could be faced with a severe penalty under the Act. It also means that you could suffer severe reputational damage. So with all of this in mind, let's consider our two unusual POPIA aspects. As our first unusual aspect, the concept of working from home. Now, this became the new normal for most of us during the COVID-19 pandemic. But from a data privacy perspective, it's perhaps a little unusual, and there is a very large possibility that data privacy has fallen through the cracks during these unusual times. This is particularly considering the fact that most employees process personal information in the course and scope of their employment, be it the personal information of other employees or that of customers of the employer. So, with that in mind, let's consider our first unusual aspect, which is the concept of working from home. Now, this became the new normal for most of us during the COVID-19 pandemic. But from a data privacy perspective, it's perhaps a little unusual, and there's a large possibility that data privacy has fallen through the cracks during these unusual times, particularly considering the fact that most employees process personal information in the course and scope of their employment, be it the information of other employees or that of customers of the employer. So if an employee works from home, be it on a company computer or on their own device, that employee is possibly processing personal information. To the extent that a household member of the employee gains access to this information by, for example, working on the same device, or simply because the employees left their device unsupervised, it amounts to a form of unlawful processing of personal information under POPIA. It might seem like quite an extreme example, but a number of negative consequences could flow from this unauthorized access to personal information, particularly depending on who your clients are and who's gained access to the information. In addition, employers also have increased liability for the conduct of their employees under the Act, and it goes further than vicarious liability under the common law. POPIA enables a person or the information regulator to institute an action for damages against another person who'd be known as a responsible party for breach of the provisions of the Act. And this is irrespective of whether there was intent or negligence on the part of that responsible party. A responsible party includes an employer. So this means that an employer could be held liable if their employees breach the provisions of POPIA, notwithstanding the fact that there was no intentional or negligent conduct on the part of the employer. The point being is that information is more vulnerable to unlawful processing at home, particularly if employees are allowed to make use of their own personal devices. And to the extent that employees do process personal information at home, an employer needs to ensure that measures are being implemented to limit the risk of the employees processing that information in breach of the Act. So this includes implementing policies, workshops, and providing information campaigns to educate employees about POPIA. Moving on to our second unusual aspect, which relates to direct marketing. Now, this again might not seem unusual, particularly given the amount of insurance-related messages we all receive on a daily basis. But the commencement of POPIA changes the position with respect to direct marketing, and direct marketers will need to ensure that they are compliant with POPIA. Currently, unsolicited communications can be sent, provided that the recipient hasn't requested the marketer to refrain from sending those communications or opted out of receiving those communications. So this is known as an opt-out regime. Under POPIA, marketers are only allowed to send unsolicited electronic communications to people who've consented to receiving those communications or who are existing customers of the marketer. In other words, the person receiving the communication must have opted in. In addition, a marketer can only send unsolicited communications to someone on the basis that they are a customer if the marketer obtained the customer's contact details in the context of the sale of products or services, and it relates to the marketer's own similar products or services. A customer must also be provided with an opportunity to opt out when the customer's information is collected and every single time thereafter when an electronic communication is sent to the customer. It's important to note, though, that POPIA only covers direct marketing by means of electronic communications. This includes text, voice, sound, or image messages that are sent over electronic communication networks. It unfortunately excludes telephone calls. So the opt-in approach will not be required for unsolicited telephone calls, but the existing opt-out rules will still apply. So in these unusual times, it's quite important for businesses as well as the employees to ensure that they become POPIA compliant. In addition, you should also ensure that you're aware of your rights under the Act, such as knowing when to opt in and when to opt out. Thank you.
Thanks, Danielle. We've got Danielle Robertson and we've got Donnie Strachen, partner from our Pretoria office, joining us in the Q&A. We're going to be quite snappy with the questions here, but I've got one for each of you. My first one for Danielle is a GDPR POPIA question. The question is, if your company complies with GDPR, will it also comply with POPIA?
So thanks, Nick, for the question. The simple answer here essentially is no. To a large extent, the substantive obligations that are set out in the GDPR are similarly required by POPIA. So if your business has taken some steps towards being GDPR compliant, you can maybe say that you're more or less halfway. But to a large extent, POPIA is actually more stringent than the GDPR. So the POPIA provisions applies to the processing of personal information with respect to both juristic persons as well as natural persons, whereas the GDPR is limited to the data information of only natural persons. So as I said, if you are halfway there, in complying with the GDPR provisions, you'll still need to just, seek out legal advice to ensure that your company is also compliant with POPIA. And if you want to take up the task to just go over the provisions of the POPIA compared to the measures that you have in place, you can definitely do that as well.
Fantastic. Thanks, Danielle. Donnie, there was a question about generic templates for dealing with the POPIA Act. And is there some resource that the attendees of the Crammer could use to get the information ready for July 2021?
We have a document, thanks Nick, we have a document that sets out sort of the basic steps that people need to take when they start looking at complying with POPIA. Unfortunately, for POPIA, you can't follow a cookie cutter approach. It's very difficult to say that you can pull out these 5 templates and then you are going to be POPIA compliant. Unfortunately, businesses have to tailor make their approach to their own processing of personal information, but we can definitely share some easy steps, pointers where people should start off with. Unfortunately, POPIA requires a long journey and you have to be prepared for that journey. So there are some tools that we can provide, but unfortunately the trick lies in implementing all of that in your own business.
Fantastic. I'll ask our marketing team to just put some of the content from our website up on some of the basic steps for preparing yourself for POPIA. So I think perhaps the answer is you're not gonna find any worksheet that's gonna get you ready, but if you can inform yourself and read up on exactly like what the founding principles and requirements are could put you in a good position for, once you do approach your lawyers to give you a clear roadmap on how to deal with POPIA. Would you agree with that, Donnie?
Yeah, definitely. I think there are some easy steps that you can follow. Although POPIA is quite a complicated, long act, some things are not that complicated. I think it's important for businesses to get the basics in place, and I've found that many businesses struggle to just get out of the blocks, and I think it's not that complicated. So, no, there's hope for people that are worried about POPIA.
Fantastic. Thank you, Donnie. Thank you, Danielle. Very useful, and apparently some articles are going up as we speak. Our next section of the Crammer for today is our unusual stories, which I discussed earlier. The first unusual story is by a client of ours, Sunay Nadine, and she's runs an independent design and animation studio and has some very interesting stories about the challenges she faced after launching her own business a month before lockdown. If we can switch to that unusual story. Thank you.
Despite it feeling like 2020 has let us down, the year of vision and growth kept its promises in ways we never expected. We learned to look at the world differently and understood more deeply what is essential. My name is Sunay Nadine, and I'm an independent design and animation director. I started up my own creative studio less than a month before SA went into level 5 lockdown. Like many creatives, I started a 21-day series as a reminder of all the useful things one could do while being in lockdown. I've really come to appreciate the value of a supportive community. Friends and family were referring me to colleagues and startups, or even got in touch to get their own startups off the ground, while everyone was learning to pivot. Then, after 2 months of being a small business owner, I found out that I had a spinal cord tumor. This meant taking 1 month off work to get urgent surgery. It was a time of reflection for me, and getting a clearer vision of what is really important. Later, through a good copywriter friend, I landed a great project with a sustainable energy company. This launched a series of exciting projects, ranging from branding to UX and UI design, online learning, and even an illustrated children's book. 2020 challenged me to be patient and to remember that we're all in this together.
That was fantastic. Thank you, Sunay. Next up, we've got Greg Ivans from Novo Brands, Novo Brands responsible for the famous Waboba ball, the ball that if you're throwing at the beach and your brother doesn't catch, just carries on traveling and bouncing off into the distance. And the beer bird, where you put a beer on your Weber. Fans of both of these products. Beers, birds, Wabobas. Yeah, let's switch to Greg's video. Thank you, guys.
Hi, I'm Greg Ivans, one of the co-founders of Novo Brands. Novo Brands is a product sourcing and distribution company. We source and distribute various branded products from around the world through our network of retailers. We've got retailers in various sectors, from the mass retailers through to the chain stores and a few independent stores as well. Although 2020 has been an extremely tough year for everyone, there have been a few key learning points. One of the key learning points for our business is that we've had to listen up more carefully to our customers and be empathetic with their needs. And they're operating in a very, very tough environment, and we've had to take a lot more of a collaborative approach with them in order for them to achieve their retail goals.
For more information on our brands and products, go to www.novobrands.co.za.
That was great. Final section for today is wrapping up from the week of our Crammer that's been running since Monday. I'm going to hand the Waboba over to Jenny Pinar, who's going to give us a summary of Monday's Crammer, and we'll then move through Tuesday, Wednesday, and Thursday. From me, I'd just like to say thank you very much for attending today, and we're very grateful to have so many attendees. The comments and the questions have come thick and fast, and there's been a lot of engagement, and we look forward to discussing these issues with you again in future. Thank you.
Good morning, everyone. Thanks, Nick. I'm not sure if I caught the ball from you there, but I certainly caught the fever of how amazingly unusual this Crammer has been for us. I think for each of us, it's been a fantastic experience. And on Monday, when we spoke about unusual times and we looked at how COVID-19 impacted from small business, from a competition perspective, to trying to make sure that you've got your copyright tied up when you ask a designer to create something for you, right down to getting one of our leading advocates at the Johannesburg Bar to tell us what it's been like to try and be a wonderful advocate in the way you present your arguments to court through a virtual court system. So I hope that we've inspired you. I think the unusual stories will keep amazing us and making us realize how adaptable we can be in these unusual times. So then I'd like to hand over to Darren, who will do the wrap on how Tuesday's sessions went. Thank you so much for joining us, everyone. See you again next year.
Thank you very much, Jenny. Yes, Tuesday was a really good event on the workplace. We discussed a comprehensive survey undertaken by Savile Row architects. They put it on the workplace survey and established that one of the fascinating aspects is 88% of people would prefer to have a work from home environment or a combination of work and office. And that's quite a large statistic. That's on the back of Microsoft announcing that they have a permanent given their employees a permanent option to work from home. So we deep dived into some of the aspects of this. Of course, the employment lawyers, Aslam and Tandeka, were up in arms, well, not quite, but just really looking at this concept of a place of work in your contract of employment and really encouraging listeners to change their contracts and how to collaborate and speak with employers to get these changes through. And as well as looked at some of the obligations on the employer to really uplift areas in which perhaps it's not conducive to remote working. So that's going to be something to look out for. We then had a human capital expert come on board, Leon from People Beyond, who spoke about the opportunities of working in a remote workplace, especially opening the door to giving the option of delivering services internationally, but some of the challenges that it will also, no doubt, create. Lita, of course, are innovation experts in commercialization of IP, latched onto the fact that only 7% of those who have changed their workplace policies and contracts have paid any attention to intellectual property. Intellectual property, of course, is the cornerstone of protecting and nurturing innovation, and as a result, we would advise.
Thank you, everyone. Thank you for joining us for this year's Crammer. I've been involved in the Crammer now for a couple of years, and this is perhaps the most unique way we've ever done it, in keeping with the unique challenges that we've dealt in 2020. It's inspired me to think of new ways of bringing content to our clients, and I really hope that you enjoyed it as much as I enjoyed being involved in it. I'd also like to thank all the people that were behind the scenes putting this all together. This is an amazingly difficult thing to put together, and I think for the most part everything has worked out smoothly with one or two technical difficulties here and there. On Wednesday we had an opportunity to discuss some of the challenging issues that legal obligations have faced in this year. Some of the things that we've really taken for granted in the past years have become a bit of an issue this year, and I'd hope that people can at least take examples of these difficulties and apply them to their own personal circumstances. We looked at issues in the construction industry, with regards to lease agreements and with regards to insurance claims. So I really hope that everyone enjoyed it. And I look forward to seeing you all again here next year. Over to you, Peter.
Hi, everyone. Hi again to those of you who joined us yesterday on Thursday, those of you who didn't. Our session related to unusual opportunities and how to see, how to appreciate and make use of those, as well as how to understand some legal considerations relating to these opportunities. We firstly had Portia Manzini, one of our associates, discussing business rescue with expert advocate Johan Smith. And they conveyed to us the importance that business rescue should in many respects be seen as an opportunity and not as the beginning of the end. If implemented timeously and with the assistance of a skilled team, the rescue effort may end up being just that. Our second talk was by Tapelo Montong, one of our senior associates. He discussed the sudden relevance that a revolutionary technology such as 3D printing found during the pandemic in meeting the need for rapid manufacture of products such as personal protective equipment. And he also touched on some intellectual property considerations and highlighted many challenges that IP owners might face in enforcing their rights against infringers. But he emphasized, and that's, I think, an important takeaway, that a comprehensive and a sophisticated IP protection strategy relying on copyright, registered design protection, and patent protection still provide valuable basis from which to address commercially harmful infringement, and one should not dilute that those strategies. Our final talk was a very interesting and topical one on the COVID-19 pandemic between Dr. Charlene Rupp-Narain, one of our senior associates, and Dr. Yvonne Holt, the Chief Medical Officer of Next Biosciences. Dr. Holt provided us with valuable facts around the nature of COVID-19 infections and testing, and she dispelled some fake news that we may have heard and distinguished particularly between PCR testing and antibody testing. And Charlene gave us some intellectual property context to the development of vaccines and therapies and what's within the realm of possibility of being protected in South Africa. And she also touched on the IP protection in the context of global cooperation that we're seeing. And she emphasized that IP protection should not be seen as obstructive to such cooperation, but rather as an enabler thereof, and that to some extent at least, the existence of intellectual property protection has contributed to the possibility of having all of the medical technologies and therapies that we have available to combat this challenge that we are facing. With that, I'm going to hand back over to Darren. He's going to close this session and this year's Crammer. From my side also, I echo the sentiments of earlier speakers. It was really enjoyable to do it on this platform, and we hope that you also enjoyed it and you bared with us and the challenges that we may have faced. And we'll see whether next year we do it in the same manner or whether we'll be able to see each other in person. Darren, over to you.
Thanks very much, and again, also thanks sorry about that earlier glitch, and that actually brings me to talking about this event and giving some thank yous at the end. The first thank you, of course, is to the audience itself. Thanks very much for attending, taking the time out to listen to us, and being very gracious in putting up with some of the technical glitches that happen from time to time with an online Crammer like this. Just to reiterate, some of our decision-making in taking this next year online, or whether we're going to have it face-to-face, or perhaps a combination of both, will be dependent on your response, please, to the surveys that we have sent out with each Crammer session. So we'd be really grateful if you could please just complete those up, and so we can take that into our planning and make it a really great experience for you next time as well. Those who have taken the time to send in unusual stories, really that has been a fantastic contribution to this year's Crammer. Not only are they learning experiences, they're very humbling, many of them, and very inspiring. And I hope, as speakers, I've certainly found it inspiring, and I'm hoping that the audience has too. That's going to endure past the Crammer. We do encourage more unusual stories to put up on the platform. We're going to promote them on our social media platforms to give you coverage, and hopefully reflect on them at other events as well. So it's not going to die. So please keep them coming. To the facilitators, Jenny, Tandor, Peter, And Nick, thanks very much for your contributions, getting your days together and putting up with all the tough stuff that does come through in these types of events. The speakers, especially the guest speakers who've taken time out, sat in front of green screens to put content in. It wouldn't be here without you. So really, thanks for that. I hope you guys have enjoyed it as much as we have. And then finally, our internal and external production team, last but definitely not least, those people behind the scenes who really take the most stress. I'm talking about Natalie, Joy, Susan, Lindelwe internally, and Marnus, Manisha, and Sam externally. Really, guys, it's been wonderful working with all of you. This type of event takes us away from our day-to-day, grind, billing hours, whatever it might be, filing applications, and it's really a joy to be part of. And thank you, everyone, for their contribution. And finally, once again, thanks to the audience. Please don't forget that if you missed any sessions of the Crammer, they're all going to be uploaded onto our microsite. And without any further ado or delay, have a great day. Enjoy Friday. Enjoy your weekend. That's a wrap.